Hi, welcome. My name is Amy Borquist. I'm the Associate Program Director of the International Justice Program at the Advocates for Human Rights, and I coordinate our advocacy on death penalty issues at the United Nations. I'm here today to give you a training overview for the reports you're going to be working on death penalty issues that will be going to different treaty bodies at the United Nations. So this is designed to be an overview training for all of the different Promoto teams that are working on these reports. And then we'll have a follow-up call to answer any specific questions about the reports you're working on. The agenda for this recorded training is, first I'll give you an overview of UN human rights mechanisms and how treaty bodies fit into that set of mechanisms. Then I'll talk a little bit about the death penalty issues you may want to look out for as you prepare your reports. Then I'll go through some of the nuts and bolts of writing the reports that you're working on. And then I'll talk somewhat about general principles about making smart recommendations and working with partner organizations. If your team is one of the lucky ones to have a partner organization to work with. First, a little bit about the Advocates for Human Rights. If you're not familiar with our organization, we're based in Minneapolis. We were founded in 1983. And our mission is to implement international human rights standards in order to promote civil society and reinforce the rule of law. We have at the United Nations something called special consultative status, which gives us some additional access that other civil society organizations don't necessarily have to be able to take the floor of the Human Rights Council, to host side events and do some other things. And when we work in partnership with other organizations who may not have that special consultative status, we allow them to piggyback on our status and really leverage our access so that their voices can be heard in those UN bodies. The Advocates for Human Rights has for quite some time been a member of the World Coalition Against the Death Penalty. And all of the reporting that we do on death penalty issues is in collaboration with the coalition, and as if circumstances allow, with a coalition member in the country or focusing on the country that is coming up for the review. Part of the theory of change that we have in working toward abolition of the death penalty around the world is this connection between the global and the local. We have our local partners working to abolish the death penalty in their home countries. They don't always feel heard by the governments who are supposed to be representing them and their interests. They may, try to collaborate with them to work toward abolition, but what the role we play is helping them share valuable information and priorities with international human rights bodies, and that, like the treaty bodies we'll talk about today, and then those international human rights bodies then can exert influence on the governments of their countries to try to press them from the outside to push for change, to complement the pressure that they're feeling from the inside from civil society organizations on the ground. So it's really an important combination of advocacy strategies. So first, that overview of UN human rights mechanisms. There are a lot of different UN bodies. Important for you to pay attention. We'll be focusing on the treaty monitoring bodies, which is the third column. But there's also the Office of the High Commissioner for Human Rights, which is kind of the administrative body overseeing human rights at the UN, the Human Rights Council, which is a more political body, and then you have regional and other human rights bodies that are also part of this whole system. But we'll focus today just on the treaty monitoring bodies, but just know that there's a bigger world out there beyond what you're going to be focusing on for your reports. So looking at the treaty-based mechanisms, as the terminology suggests, there's a treaty connected to each of these mechanisms. And there are 9 principal human rights treaties coming out of the United Nations. The ones that are in green are the ones we'll focus on today, because those are going to be the targets for our advocacy over the next few months. Those are the ones your reports will be targeting. And you can see the different subject areas. And just because we're not focusing on a subject area doesn't mean it's not important. It's just because of the timing and the scheduling that there aren't opportunities coming up for those particular ones. But we will focus on the treaties and their respective treaty bodies relating to economic, social, and cultural rights, the rights of children, racial minorities and racial discrimination, the rights of women, and torture. This is kind of the way things break out in terms of the different treaty bodies and what projects we have coming up. You'll see there are 4 different reports to the Committee on the Rights of the Child, which oversees the Convention on the Rights of the Child. There's one for Iran at the list of issues stage. And then there are reports for Malaysia, the Maldives, and Uganda at the later stage in the process called alternative or parallel or shadow reports. Then for the CEDAW committee, which is the Committee on the Elimination of All Forms of Discrimination Against Women, we have initial reports on Brunei Darussalam and India, and then later part of the cycle on Iraq and Vietnam. Then for the Committee Against Torture, we have just the early stages of the review for this particular committee. That's Nigeria, Somalia, and Uganda. And then sort of one-off reports, one regarding the Maldives to the Committee on the Elimination of Racial Discrimination, and one on Laos for the Committee on Economic, Social, and Cultural Rights. And I'm just going to give you an overview of each of these treaties. In your reports, you shouldn't be talking much, if at all, about the substance of the treaties themselves, because your audience, these are experts on the treaties. So you don't need to tell them what their treaties mean. They know very well what their treaties mean and what the scopes of those treaties are. But it's important for you to have that background so that you understand the expertise that your audience already has, and so you can frame things in a way that will be persuasive with your audience. Which is these treaty body experts. So the first treaty, in no particular order, the first treaty is the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, which entered into force in 1987. And you can see it's widely ratified, the dark blue. There's just a handful of countries, 24, that have not yet ratified the treaty. And important things from the treaty language. First, it's important to keep in mind the definition of torture in the Convention Against Torture. It's intentionally inflicted pain or suffering for one of any of the purposes that are enumerated, or it could be for any purpose, but based on discrimination, when it's by a public official or with the consent or acquiescence of a public official. But there's an important caveat that torture doesn't include pain or suffering arising only from inherent in or incidental to lawful sanctions. So that's where there's some division in opinion of international human rights scholars about whether the death penalty per se is a form of torture. And there's at least a decent argument that this last part of the definition of torture means you can't really argue that the death penalty is always inherently a form of torture just because of that language that you see there. Notwithstanding that language, the experts who interpret the Convention Against Torture do frequently address the death penalty without going into any analysis of what Article 1, Paragraph 1 says about the definition of torture. They're still concerned about the death penalty. They still want information about the death penalty, and they will make recommendations about the death penalty if they have that information at hand. Just as an overview of other provisions in the Convention Against Torture that may be relevant to your reporting, government has an obligation to prevent torture. Non-refoulement means that a government that's ratified the Convention Against Torture can't send somebody to a country where they're at risk of being tortured. The governments have to criminalize torture. Important, particularly typically for our death penalty reports, the government has to train law enforcement and others involved with custody and interrogation so that they're not using torture or cruel, inhuman, or degrading treatment to extract confessions. And that happens a lot in our death penalty reporting, that we'll see that countries do engage in torture to try to extract confessions that then lead to capital sentences. So that's a really relevant issue. If you can find evidence of that, please include it in your report. Courts are supposed to exclude evidence obtained through torture at trial, and the state parties that have ratified, governments that have ratified the Convention Against Torture also are under an obligation to prevent cruel, inhuman, degrading treatment or punishment. So it's important to understand that framing, but again, in your report, you're not going to go into detail about what these particular articles say. You just need to have this framework in mind as you prepare your reports. Next, we'll cover the Convention on the Elimination of All Forms of Discrimination Against Women, entered into force in 1979. And again, just 8 countries in the world are not parties to that convention, including the United States, unfortunately. And this is a convention that isn't intuitive in doing death penalty advocacy, but the Advocates for Human Rights has really stepped up its advocacy with the Committee on the Elimination of Discrimination Against Women relating to the death penalty with a lot of great success over the last, I would say, 4 or 5 years. We're really highlighting women under sentence of death in a variety of countries and the discrimination that they face at different stages in criminal proceedings, from prosecution, from the trials themselves, and sentencing. And there's a lot that we have the opportunity to talk about in our reports. So the state party obligations from this convention, they talk about discrimination in Article 1, and we need to make sure that women don't face discrimination in all aspects of their encounters with the criminal legal system. So there's a lot of research out there that finds that women are sentenced to death not so much because of the severity of their criminal behavior, but because they act contrary to gender norms. So it might be a woman who kills her intimate partner, for example, and she gets painted in the criminal legal proceedings as some kind of a Jezebel or something like that, gets characterized with gender stereotypes that sort of paint her in a really negative light for doing something where there may have been a context of intimate partner violence, for example, and she was acting against her abuser and may have felt that that was the only way that she could escape an abusive situation. And the courts don't consider that evidence in mitigation in determining an appropriate penalty. So discrimination is an issue that we highlight in our reports to this committee. Article 2 covers the general obligations of countries that have ratified the treaty. Something that's also potentially important for you to keep in mind in your reports to this committee is the idea of stereotypes and prejudices, because those often play out in criminal legal proceedings against women who are charged with capital crimes, about what appropriate behavior is and what inappropriate behavior is, and those stereotypes can play out in a lot of different ways. And then finally, equality before the law. Women should be treated equally before the law, shouldn't be treated differently because they're women in conflict with the law. Next, we'll jump to the Convention on the Rights of the Child, a relatively newer convention, entered into force in 1990. And yes, you're looking at that map correctly. The United States is the only country in the world that has not ratified the Convention on the Rights of the Child. We'll just let you pause and think about that. In terms of what we see, most countries don't sentence juvenile offenders to death. There's not usually a lot to talk about with respect to the Convention on the Rights of the Child, but there are some countries that have problematic conduct that affects the rights of the child. Article 2 of the convention just defines discrimination in the context of discrimination that children may face. And it's not just children, it could be discrimination as well based on nationality or ethnicity or religion and all sorts of other factors. Article 6.1 says that states parties, meaning countries that have ratified the treaty, recognize that every child has the inherent right to life. And then it's really Article 37 that is applicable to children, what we call children in conflict with the law. So children are defined, generally speaking, under the treaty as any person under the age of 18. And you'll see Article 37A says that no child may be subjected to torture, etc. That seems pretty obvious, but also specifies that neither capital punishment nor life imprisonment without parole shall be imposed for offenses committed by persons below 18 years of age. In other words, you can't sentence anyone to death or sentence them to life without parole if they were under the age of 18 at the time of the offense. So that's a pretty clear, well-established international human rights standard. Nonetheless, there are countries that do, in fact, sentence people to death for crimes they committed when they were under the age of 18. Some of them interpret this language, although it's not clear how and why they do this, but they interpret this language to mean that you can't execute them if they're under the age of 18, but that's not what this says. So Iran, for example, will argue it holds on to the offenders and waits until they turn 18 to execute them. So that's important language to consider. Another important consideration that's not spelled out directly in the treaty, but the treaty experts will be interested to hear about this, is in countries where there may be issues with documentation and birth records. The international human rights standards say if there's any doubt about whether an offender was 18 years of age or older at the time of the offense, the prosecution should bear the burden of proving that the person was age 18 or older. It shouldn't be the burden of the defendant to prove that they were not. So it's just sort of that burden shifting, and that's a standard thing in international human rights where somebody's life is at stake. The state should bear the burden of proving the age of the offender. There are also prohibitions against arbitrary deprivation of liberty. So that would be something relevant to talk about if the country has the death penalty for something that shouldn't be a crime at all, like same-sex conduct, or for exercising freedom of religion, for example. So though that would be, if children are imprisoned and sentenced to death for those types of crimes, that would be an arbitrary deprivation of liberty. Detention conditions are also relevant, and there's some specific language there. And children in conflict with the law have the right to legal assistance and sort of what we call habeas corpus rights, right to challenge the detention in a court of law. So those are some important state party obligations under the Convention on the Rights of the Child. Next is the International Convention on the Elimination of All Forms of Racial Discrimination. This is one of the older human rights treaties. It entered into force in 1969, and again, pretty widely ratified around the world. The important provisions are, first of all, that race includes, under Article 1.1, race includes ethnicity, but also national origin and ethnic origin. So it's a really broad thing. And a lot of things, when we do death penalty reporting to this particular committee, in a lot of countries, what we're talking about are foreign nationals. So foreign nationals who come into conflict with the law may face xenophobia in the criminal legal system, may not receive access to interpretation or their right to consular notification so that their embassies can help them mount a defense. Those are all fair game under this particular convention. It also includes linguistic minority groups if that comes up as you do your research. Article 5A talks about the right to equal treatment before the law. In other words, there shouldn't be discrimination based on race, national origin, etc., in legal proceedings. And also that the governments, the countries that have ratified this treaty have to take action to combat prejudices that can lead to racial discrimination, and racial discrimination viewed broadly to include things like xenophobia as well. So that's the Convention on the Elimination of All Forms of Racial Discrimination. Next is the Covenant on Economic, Social, and Cultural Rights. Again, this is one of the older human rights treaties, entered into force in 1966, and fairly wide ratification worldwide. This is a treaty we don't do a lot of death penalty reporting under because economic, social, and cultural rights just by and large don't seem core to the issues that we raise on the death penalty, but we do sometimes engage under this particular treaty when we want to focus on, for example, conditions of detention for people on death row, or generally conditions of detention. So one thing is like access to healthcare in detention facilities. Is there adequate food? Is there adequate clothing? Sanitation in those detention facilities? Do people in detention have access to education? The right to contact and have visits with their family? If there are employment provisions in detention facilities, do people who are under sentence of death also get to pursue those employment opportunities and education opportunities? And then non-discrimination as well. Non-discrimination is sort of a thread that runs throughout these human rights treaties, that there should be no discrimination on account of a variety of protected groups. One thing that's distinctive about this particular treaty is it recognizes that states may be in different places just due to the state of their economy and so on in being able to realize these different human rights. So the right to education in the United States might be very different from how a state like Burkina Faso realizes the right to education. And the progressive realization language in Article 2.1 is really saying that states can make progress toward achieving the access to healthcare and right to work, et cetera. But even though a country can be compliant with the treaty if they say, we're working on this, we're making progress. They can't discriminate in how they make that progress. So they can't say that, okay, all of the men in detention can get access to vocational training and education, but the women can't, because non-discrimination is always a requirement of the treaty. And we can talk more about that if that comes up as you're doing your research. Overall, these treaty-based mechanisms don't apply unless the country has ratified the treaty. So if you've been given an assignment, you can assume that the country has ratified the treaty, or we wouldn't be bothering. And each treaty monitoring body, and keep in mind, this is your audience for the reports that you're writing, it's made up of independent experts who interpret the treaty. And these independent experts have regional geographic representation, but they are experts on what the treaty means and on sort of the general overall issues that the treaty covers. They're not experts in the particular country that you're working on, and they're not experts in the death penalty. So our job is really to give them that on-the-ground information that may be relevant to their particular treaty, so that they can then apply their expertise when it comes time to doing their review of the country that's coming up for review. So now we'll talk about what that review is. It's important for you to know that these treaty-based mechanisms or committees have a lot of different functions, and the only one we're going to focus on today for purposes of this training is the state reporting function. And this is an obligation. If a country has ratified the treaty, they agree to go through this reporting procedure. And civil society organizations like the Advocates for Human Rights and the World Coalition Against the Death Penalty and our partner organizations, we have a really important role to play in that state reporting procedure. So before I dive into how that reporting procedure works, I'm going to revisit this slide so that we can look and see, the different treaty bodies on the left, and then we have LOI, LOIPR, and alternative report. And as I mentioned before, these are two different stages in the process. So LOI stands for list of issues, and LOIPR stands for list of issues prior to reporting. They're very similar types of reports that we do, and they happen earlier in the process. The purpose of those reports is really to frame the review, to try to set the agenda. And the reports that happen later on, what we call alternative reports or shadow reports or parallel reports, those are after the agenda is set and as we get closer to the actual review. So it's just a little bit farther along in the process. So now we'll take a look at the cycles, and I'll show you where each country, treaty body, etc., is in the particular cycles. The first cycle we're going to look at, there are two different types of cycles. One is the standard reporting procedure, and one is the simplified reporting procedure. So for the standard reporting procedure, most of the countries that are working on, most of your teams are going to be doing the standard reporting procedure, or your countries are going through the standard reporting procedure. And that starts at step one, where the government that's ratified the treaty submits its own report. And I like to refer to this as a self-audit. The government will go through what the treaty requires, say, here's how we're doing, here's how we've made progress, this is where we've had some troubles, and here's what we've done that's really cool. Give us a great report card. So Iran is at that stage. They just submitted their state party report, and now it's our turn with our partners at Iran Human Rights to respond to that state party report, to say, okay, here's some things the state party's report says that aren't quite true, to do some fact checking, and to identify some gaps in that state party report, and then just to share additional information to try to get it on the agenda. So what happens then at stage two is the committee will set its agenda in the form of what we call a list of issues, or LOI. So our report at the LOI stage is really to try to influence what the committee ultimately decides to put in that LOI. And that LOI really functions as its agenda, its schedule for what's going to happen later in the review process. Next, the state party usually submits a written response to the LOI, like going through the committee's questions and agenda items, and offering some more substantive information. And at that point, we get another bite at the apple. We can then respond to the list of issues from the committee, and also respond to, if there is one, respond to what the government said in its response to the list of issues. We can offer our own counter response. So for all the countries you see up on the screen, the Maldives for CERD, Laos for the Economic, Social, and Cultural Rights Committee, Iraq and Vietnam for CEDAW, and Malaysia, Maldives, and Uganda for the Committee on the Rights of the Child, they're already farther along. There's already a list of issues from the treaty body, and there should already be a state party response to the list of issues. And now we get one last chance to submit a report where we fact check whatever the government has submitted and where we respond ourselves to the list of issues. Sometimes the government will like skip over things in the list of issues that the committee experts ask for. And we'll point that out. Like, the committee asked for this, there was no response, or the response was a non-response. So we can do that, and then we can just feed additional information to the committee based on what the committee asked for. We can also feed information to the committee that they may not have asked for because they just didn't think to ask for it, or they didn't have the information at their fingertips. So we can give that additional information to the committee as well. What this is all leading up to is step 4, which is the constructive dialogue. And this is the exciting part where the government sends a delegation to Geneva and they have a 6-hour session with the experts, grilling them, a lot of back and forth, a lot of really tough questions and follow-up questions. And then the government delegates sometimes are like sweating, oh my goodness, how are we going to answer all these questions? So it's a 6-hour live webcast back and forth. And then a few weeks later, after that heated session, the committee experts published their sort of final report card, what we call concluding observations and recommendations, where they say, we commend the government of Iran for this, this, and this. We express our concern about these other things, and we recommend that the government of Iran do these things before the next review cycle. And then, of course, after those concluding observations come out, then there's follow-up. The state party is expected to implement the recommendations that the treaty body experts give. They don't always do so, or they don't always do a great job of implementing them, but at least it's an important pronouncement from these experts to say, hey, you really need to clean up your act on this, you really need to fix this. So even if the government doesn't do anything, it really gives our partner organizations a platform to say, look, these UN experts were railing on our government about these issues, and we really, they need to take control of things and really correct the issues that the human rights experts have pointed out. So that's the standard reporting procedure, and it's pretty straightforward. And you can see here where your particular report falls in that procedure if your report is there. We also have a handful of countries and reports that are following the simplified reporting procedure. And that's Brunei Darussalam and India for the CEDAW committee, and Nigeria, Somalia, and Uganda for the Committee Against Torture. And all of these reports are at this first stage in the process. And basically what the simplified reporting procedure does is it just skips that first step where the state party submits a report. State party doesn't submit a report as the first step. The first step is the committee sets the agenda. So we get to get our foot in the door before the committee sets the agenda, before the state party says anything. We get to say, committee experts, please put these issues on your agenda, issues related to the death penalty. So that's our goal for those reports for Brunei Darussalam, India, Nigeria, Somalia, and Uganda. We want to say, please put these death penalty related issues in your list of issues prior to reporting, or LOIPR, because it's the simplified procedure. And then what will happen is the committee will publish that LOIPR. Then the state party, the government, will submit written responses. Then we get another chance to submit a report after the responses come in. And then there's that constructive dialogue, just as there is for the standard reporting procedure. Concluding observations and recommendations are the same, and then the follow-up is also the same. So it's just a little bit faster. It skips that one step of the first state party report at the beginning of the cycle. So those are the two types of procedures that we're following. And now I'm just going to give you an overview of death penalty issues. And some of these may or may not be relevant for the country that you're working on with your team. But this is just an overview, and I'm happy to consult sort of with the individual teams if you're having questions, but it's really, these are things to keep your eye out for as you do your desk research, and if you have a partner organization for you to work with, as you talk to the partner organization. Common issues that arise. First is what crimes are eligible for the death penalty. So you'll want to look at the penal code or the criminal code of the country you're working on and identify all the crimes that are eligible for the death penalty. International human rights standards say that the death penalty should be applied, if at all, only to the most serious crimes. That's the language. And what does most serious mean? It's been interpreted by various international experts to mean that a most serious crime has to involve an intentional killing committed by the person who is in danger of being sentenced to death. In other words, for the person who's going to be sentenced to death, you ask, did they in fact kill? And did they intend to kill? If you don't meet both of those criteria, then it's not a most serious crime and it shouldn't be eligible for the death penalty. So that's an issue to look at, and you can just look at the criminal code and say, okay, these are all the crimes that this country allows or makes eligible for the death penalty. These don't rise to meet the threshold of most serious. And then you'll also want to say, like, are people in fact being sentenced to death for crimes that don't rise to the level of most serious? It's not just what's on the books, but what happens in practice as well. The mandatory death penalty is another human rights violation. International human rights standards guard against the arbitrary deprivation of life, and sentencing somebody to death on a mandatory basis means that the court, by definition, can't consider the facts and circumstances of the offense or of the offender, can't take into account those particularities when determining what the penalty is, and therefore the mandatory death penalty is arbitrary because it doesn't allow for consideration of those factors. So the mandatory death penalty is something else to consider. Juvenile offenders, we've already talked about. Courts should not be sentencing to death any person for an offense that she or he committed when she or he was under the age of 18. We also will talk about people with psychosocial disabilities or intellectual disabilities. It's not per se a violation of international human rights standards for those people to be executed, but oftentimes we see that people with severe psychosocial disabilities and intellectual disabilities often are not receiving the accommodations that they are required to receive by the criminal legal system, and don't receive fair trials as well. There are other fair trial issues you may want to look out for. For example, does the person at risk of being sentenced to death have access to legal counsel at all stages of the proceedings? Is that legal counsel well qualified? Are they paid a pittance and just forced by the court to represent somebody, in which case they may just show up to trial having done no preparation, having not even interviewed their client. So even if there is a lawyer representing the person at risk of being sentenced to death, we want to look at making sure that they are sufficiently compensated and sufficiently trained with experience, specifically handling capital cases. Torture and cruel and inhuman and degrading treatment is also relevant at the fair trial level because of law enforcement officers often using torture or other forms of ill treatment to extract confessions or to get statements from witnesses that are then used to secure a death sentence. So that's another fair trial issue that you may want to raise. We also see fair trial issues about the impartiality or partiality of the judiciary. In some countries, the judicial branch is not independent. It is largely under the control of the executive, and the executive may use the judicial branch to seek out punishment for its enemies or its critics, for example. And so there are fair trial concerns there. Another thing you may want to raise in your report is detention conditions. And oftentimes we can't find specific information about detention conditions for people under sentence of death. If you do find that, that's wonderful. But if you just have general information about detention conditions, you should feel free to include that in your report if it's relevant. And then international human rights standards say that every person under sentence of death should have the right to appeal. So make sure that that is something that's allowed. If it's not, flag it in your report. We'll also look at execution methods. And we typically don't mention what the method of execution is in our report unless there's some risk because of that method, some risk of the execution itself being cruel, inhuman, or degrading, or a botched execution, for example, like the lethal injection executions in the United States that have been botched and prolonged the agony of the person being executed, or a method of execution that's sort of inherently cruel or involving inherent torture, like stoning someone to death, for example, or crucifixion. Those might be execution methods that you would raise if that's an allowed, a permissible method of execution in the country you're looking at. Gender and the death penalty is an issue we've been doing a lot more work on in our reporting over the past few years, as I mentioned, with the CEDAW committee, the Committee on the Elimination of Discrimination Against Women. And there are a lot of really interesting issues about women, gender, and the death penalty, even though women make up globally, probably about 5% of the population of people under sentence of death. The overwhelming majority of those women faced gender discrimination in the criminal legal proceedings that led to their death sentence. And so those are important issues to raise. Whether you're doing a report to the CEDAW committee or to some other committee, if you find that information, please include it. And then we talk about discrimination more generally, discrimination that migrant and domestic workers or foreign nationals may face. It may be that in your country, ethnic, religious, or linguistic minorities are at greater risk of being sentenced to death for various reasons. And in some countries, members of the LGBTIQ plus community may be at heightened risk of being sentenced to death, either because same-sex sexual conduct may be criminalized or may be subject to the death penalty, or because they're targeted by law enforcement for whatever reason. Another set of issues to look out for is human rights defenders, and that might be civil society organizations, it might be attorneys representing people charged with capital crimes, maybe individual activists who speak out against the death penalty. In some countries, they face reprisals or persecution because they advocate against the death penalty, and that's another topic to include if you find relevant information. We have a much longer training video that does a much deeper dive into death penalty issues, and I'll make sure you get the link to this training if you want more sort of background about the types of issues you might keep an eye out for as you do your research. Now we'll jump into writing the report itself. The format, you should be writing in Microsoft Word. If you have not already received a template, you'll be getting one soon. There will be a cover page that the template has already started for you. There's not usually a page limit, but usually these reports are usually 5 to 15 pages. If it's getting longer than that, come and let me know, because something is off, I'm guessing. And some of the treaty bodies do have word limits and do enforce them more strictly, like the CEDAW committee in particular. It's pretty strict about 6,600 words, including footnotes and the cover page, I believe. So that's the big stickler is the CEDAW committee. So we need to be careful there. But usually it's not super strict. You do need to make sure that all pages and paragraphs are numbered. Paragraph numbering is really important for the UN because a lot of things get translated and the pagination may shift as things get shifted into different languages, but the paragraphs can always stay the same. It makes it easier. Use footnotes, and I will also ask that you please have mercy on me and don't use any IBIDs or supras or anything like that at this stage. When I get your draft reports, I sometimes will do some reorganizing. I'll sometimes cut out some things that maybe don't seem as relevant, or things get moved around. It's really hard for me if I'm moving things around and then an IBID gets removed from its initial reference, or if there's a supra and then that supra footnote gets misidentified. So if you can just put the full source citation in every footnote, that will make my life a lot easier, and I will be very, very grateful. One thing I did want to talk about briefly is using people first language. It's really important in using our language because we are all advocates for human rights, and that includes all of you working on these reports. We want to emphasize the human in human rights, and we want to make sure that we're not dehumanizing the people that we're talking about who have their human rights being violated. So when we talk about people who are under sentence of death, we don't call them prisoners. We don't call them inmates. We don't call them the condemned. We will talk about people in detention, individuals in detention, people under sentence of death. So just use people first, literally. And then people with disabilities, not the disabled or the insane or things like that. You can certainly say LGBTIQ plus people if that's appropriate given the context, but otherwise try to use that people first language as best you can. Keeping in mind that you're writing this report, I mentioned this earlier, but keep in mind who your audience is. And our audience for these reports is this committee of 12 to 20 experts on the particular treaty you're focusing on. So they know a lot about the rights of the child or racial discrimination or women's rights or torture related issues. They are very familiar with what the prohibitions are against torture, for example. But they're not experts on the country that you're working on, and they're not necessarily experts on the death penalty either, but they're experts on sort of the substance of what the treaty says. They're the ones who ultimately are going to be writing those recommendations, issuing that report card to the government. So they're our primary audience. But we also have sort of a secondary audience of the government of the state under review. We actually hope that the government will read our report and see what we're saying that may be critical of them. Maybe they'll learn a thing or two. And we want to use, these reports can be used as an advocacy tool to try to press the government to change. Even if the treaty body experts don't say something, the government should, we hope, be responsive to the sort of criticism that these reports can offer. And our audience may also be, and sometimes this depends on our partner organizations, the general public. We sometimes use these reports as like an educational tool to help the general public, especially in the countries that are being reviewed, to help them learn more about what's happening in their country. And that can be a really effective use for these reports. So keep in mind all three of those audiences as you're reporting. Sometimes we will reference specific articles of a treaty, not so much because the treaty body experts need to know this, but just because we want to have that frame of reference for our other audiences, our second and third audiences for the reports. For a list of issues reports, and don't worry, I'll flash up on if you don't remember from the slide before who's doing a list of issues report, we'll get that information to you. The committee publishes that list of issues, LOI, or list of issues prior to reporting, LOI-PR, that helps set the agenda that the committee is going to use for its upcoming review. And our goal when we're doing a report at this stage is to make sure that our issues get included in that list of issues or list of issues prior to reporting. We also have a goal of gathering information from the state party, because in that list of issues prior to reporting that the committee publishes, the committee will request information. And so if we can get the committee to request information that we don't have and we want, that can be a really effective tool. Like we have partner organizations who are like, we don't know how many people are on death row. We don't know how many women are on death row in our country. And I'll say, let's try to get this treaty body to ask for that information at the list of issue stage. And then sometimes we'll attach like a whole list. We did this with Ethiopia with the Committee Against Torture. We got the committee to ask for that information, and lo and behold, they sent us a whole list of the names of all the people under sentence of death, what crimes they were convicted of. It was disaggregated by gender, so we now know that there are 2 women on death row in Ethiopia, and their locations. It gave us a lot of information we didn't have, and it was because the Committee Against Torture asked for that information that we were able to get that. So gathering information is also a really important use of these lists of issues, because we know that a lot of governments do try to respond when these experts in Geneva are saying, give us your information, show us your cards. This is a way for us to extract that information in a way that we otherwise might not be able to get it. So if you are writing a report at the list of issues stage, there are several key documents you want to pay attention to. First is the treaty. And again, you don't need to be quoting the treaty in your report, but it's good for framing. And then you'll want to look at what happened in the last cycle. So what was the report card from the last review, from the last concluding observations and recommendations? That's an important document that you can use if it works, use that to try to organize your report that you're writing. So if there were like 3 different recommendations from the previous concluding observations, you can have 3 different sections to your report where you build in that information that sort of shows you're familiar with how the committee has approached this country in the past, and you're going to follow up from the previous cycle and make it easier for the committee experts to get back on track for the review. Another Another key document that might be relevant is from the previous review. There might be follow-up reporting. Sometimes the committee will select particular issues for follow-up and request a follow-up report earlier in the process from the state party report. So look for that when you get the link to the concluding observations from the previous review. And then there should be state party report and common core document. In some cases, there's no state party report. There's just a common core document, it's just like a generic report about what our country does about human rights. So you might not have much of anything at this stage, but if there is a state party report, of course, take a look at that and see what sections you want to focus on that are relevant to death penalty issues. So those are the documents that you'll be looking at. If there's no state party report, don't sweat it. Again, we're there to set the agenda. So if there's no state party report, we can still help set the agenda by doing our own reporting to the committee experts. So for the countries coming up, for the folks who are working on various reports, here's what the look back period is. So we don't want to give the committee stale information. So what we want to do at this stage, because again, we're just starting out the new cycle, the relevant look back period is when the previous concluding observations were issued, when the committee last did concluding observations for the particular country. So you can see if your flag knowledge is good enough, Iran's last concluding observations from the Committee on the Rights of the Child was in 2016. Brunei Darussalam's last CEDAW concluding observations, same with India, were in 2014. Nigeria's last concluding observations from the Committee Against Torture were in 2021. Somalia and Uganda had their last concluding observations from the Committee Against Torture in 2022. So that date to the present is the relevant period to focus on. And of course, focus on more recent information is probably going to be more relevant. But anything within that period is fair game. And if you need to go back a little bit farther just to give some context, that's fine too. But just remember, the committee experts are really going to want to focus on what's happened since their last review, since their last concluding observations. And you should be getting a link to the session where those concluding observations were issued. So you can go back and look at the concluding observations themselves and any other documentation like follow-up reporting that would be on that session webpage. We have a template for you to use. Hopefully you have that already. And this is like the cover page for the template. Should look relatively familiar to you. X is compliance, that's the name of the country. With Y, treaty, you just name the treaty. Selected list of issues, add the prior to reporting if it's an LOI PR relating to the death penalty. And then if we have a coalition partner organization, you'll want to make sure to add their name in there. And then the session, you'll be able to get from the link to the session page. So you fill in the number of the session of the mechanism, that's the committee. And then put in the start dates and end dates of the session. And then you can leave the submitted part for me to fill out once we actually submit. That's the cover page for our template. And then please follow the rest of the template. We've given you some sort of guidelines about how to do that. And I'll talk more in a little bit about how the template plays out. More on alternative reports. We also call these shadow reports or parallel reports. They're all the same thing. This is later on in the review process after the committee has issued its list of issues or list of issues prior to reporting. This is where we're getting closer to that day of reckoning when the government delegation goes to Geneva for the constructive dialogue. And so we're really giving that, that final chunk of information to the experts as they get ready for their constructive dialogue. So after that constructive dialogue, again, the committee publishes its concluding observations and recommendations. And our goal at this stage of the review process, and we often are doing reports at both stages, at the list of issues stage and at the alternative report stage. Our goal here is to ensure that the constructive dialogue raises our issues. So the committee experts have enough information to ask good questions and to really press the government. And most important, that our issues are included in the concluding observations. So we're going to suggest things we want the committee experts to say in those concluding observations, specifically recommendations we want them to make to the state under review. Your key documents at this stage are, of course, the treaty, then the concluding observations and follow-up reporting for the last review, same as with the LOI PRs, then, of course, the state party report. But what's really more relevant, because things are getting more refined, this is kind of that funnel, we're getting more and more focused. Other key documents are the list of issues or the list of issues prior to reporting from the committee, and then the written response from the state party to the LOI or LOIPR if there is a written response. So those are the key documents you're going to focus on. You'll get all of these documents, with the exception of the concluding observations. You get all the documents on the treaty body webpage for the particular session that's coming up. So that's where you'll be able to find your shopping list. So just to give you a sense of how this works, I took the CDAW committee session as an example. Again, this is a session, this is the 92nd session. The session dates are at the top, October 6th through the 24th. And you'll see the consideration of state reports. So we start with Cabo Verde and the Czech Republic. If you scroll down, you'll see Iraq as an example, and you'll see the state party report. There's an annex, there's this common core document. Then you'll see the list of issues, and you just click the plus to get the document itself. And then you'll see info from civil society organizations for the LOIs. There's a report we submitted at the LOI stage for Iraq. So we already submitted a report then. Now we're doing our second report to the same committee, building off of what was said before. So for the look back period for these shadow reports or alternative reports, it depends on what we've already done. So in the case of, starting from right to left, for Malaysia, we submitted a report at the list of issues stage to the Committee on the Rights of the Child in 2024. So you're not going to go back farther than that, probably, unless we missed something really big in 2024. You're just going to look at any new information over the past year that would be relevant, and then responding to the list of issues and the state party report. For the Maldives, we just submitted yesterday a report to the CERD committee, the Committee on the Elimination of Racial Discrimination. And so this next report, our partner organization in the Maldives is trying to do some Freedom of Information Act type of request to get some more information about the foreign nationals under sentence of death in the Maldives. So we'll include that additional information if they get it, and we'll respond to the list of themes. In the case of this committee, they call it a list of themes rather than a list of issues. So it's going to be a really very narrow report, just providing an update of what's happened since then. For Iraq, we submitted a report in January to the CEDAW committee. So again, it's a very narrow window of time we'll focus on providing updates and responding to the list of issues that the committee issued, and any state party responses to the list of issues. And similar for Vietnam and the CEDAW committee, we submitted a report back in 2024. So it's a relatively narrow window because we already submitted at that earlier stage in the process. So for those four countries, it's a pretty well-defined, pretty narrow scope that you'll be focusing on. For Laos, for the Committee on Economic, Social, and Cultural Rights, they've never had a review before. They ratified the Convention on the Elimination of Convention on Economic, Social, and Cultural Rights. They ratified in 2007. They've never been through a review process. So the relevant look-back period is going to be since 2007. And again, because it's death penalty issues, we'll look at detention conditions and like access to healthcare and detention, whatever we can find that we can find some hook to connect it to economic, social, and cultural rights. And then finally, for the Maldives on the Committee on the Rights of the Child and Uganda on the Committee on the Rights of the Child, we didn't do a report at the list of issues stage. So the relevant look back period is going to be when the previous concluding observations were for that particular country. So the Maldives' most recent review by the Committee on the Rights of the Child was in 2016. So we'll look at 2016 to the present. For Uganda, it goes back even farther. You have a 20-year period. And obviously, we want to focus on the more recent information that we can get. But the look-back period that would be fair game would be since 2005, what's happened in Uganda with respect to children and the death penalty. So those are your relevant look-back periods for your treaty body reporting at this stage for the shadow reports or alternative reports. Again, you have a template. This is what the cover page looks like for the template. And you can find that session information, same as what I showed you before. It should be pretty straightforward, and hopefully that will help you with organizing the report that you draft. In terms of the substance of the report, you're going to provide as best you can. And I will say that most of the research, most of the information that goes into the report is going to be based on desk research. So you're going to be, using the internet, and we give you some guidelines in a checklist of sources to look at. Your template also has some suggested sources to look at that are credible, that we've found useful in the past. So you're going to provide recent or current up-to-date information on issues that might be of interest to the committee that have a connection or tie to the death penalty. You're going to be fact-checking or, looking at anything the government says in response to the LOI PR that might be incomplete or incorrect or might shade the truth regarding the issues that we're looking at. You can highlight omissions or non-responses when the government, in the government's written response. And you can also, and this is a really important piece, is proposing recommendations or solutions. To the extent that you've identified an issue or a problem, you want to make sure that there's a solution that would help resolve that. Of course, abolishing the death penalty can make a lot of these problems go away, but also think about more incremental solutions or recommendations you can offer in the report. In terms of good practices, a good way to frame your issues is to think forward to what the recommendations you want to see coming out of the treaty body, and then frame your arguments and organize your report accordingly. In other words, let the report justify the recommendations you want the committee experts to see. Another way to frame is to say, here's what the government's position is, or here's what the government says, or here's what the law says, and then here's what's actually happening. Here's what's actually going on the ground. Because the committee experts really love that. Otherwise they just kind of have to take the government's word for it. And a lot of times what the government is saying is not entirely truthful, or there are gaps in what the government is saying, and what's happening on the ground could be a completely different picture. So another thing that's a good practice is to use stories or examples or case studies to highlight gaps in the law or barriers to implementation. I think as lawyers, we often shy away from using just one example because, we need to have studies, we need to have comprehensive data. You can just use one example, and we do this a lot because there's so few women under sentence of death. We'll just talk about the stories of 1 or 2 women who are under sentence of death in a country and explain how gender discrimination influenced them being sentenced to death. And that's perfectly sufficient. You don't need to have this sort of comprehensive set of data to put before the committee. An individual's human rights violations are sufficient for the committee to pay attention to. Things that you shouldn't do: don't give them a lengthy procedural history. Don't go into a lot of detail about what the treaty says about particular rights. Again, they're experts, they already know that. You don't need to go into a lot of legal analysis. You typically don't need to be citing case law or statutes unless it's relevant to, you want them to amend a particular statute or something like that. Then you can certainly cite the particular statute. Don't use the tone of a legal brief. You're sharing information. You're sharing this on the ground information with the treaty body experts, and try to avoid vague recommendations too. We try to make them SMART, if you're familiar with that acronym. So an example, and this is from a report we did on Somalia, and this is at the shadow report or alternative report stage, and you'll see we have a heading here. Legal safeguards, due process, military courts, and the death penalty. And we give as a reference, and this is just to help the treaty body experts because, remember, they've set the agenda, and that agenda is the LOI or LOI PR. So we're just flagging for them. It's paragraphs 2 and 4 in the LOI PR. That just helps signpost for them so they know where this is relevant. And you'll see in paragraph 5, we say, in the list of issues prior to reporting, the committee asked Somalia to provide information, blah, 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 requested clarification, blah, 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 blah. And then in paragraph 6, shifting to the present tense, we say, here's what the government of Somalia responds. In responding, Somalia points to its constitution, states blah, 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 blah. So we give this is what the committee asked for. Here's what the government of Somalia says in response. And then paragraphs 7 and 8 are what's happening on the ground. Authorities continue to impose and carry out death sentences. They did this many executions, handed down this many new sentences, mass executions in one part of Somalia. And we think approximately 150 people are under sentence of death. And military courts continue to sentence people to death despite due process concerns. So just feeding that, here's what's actually happening. So do a little bit of framing at the beginning of each section. Here's what the committee asked for. Here's what the state party response was or non-response. And then give them that on the ground information. So the bulk of your report is going to be whatever desk research you're able to find that fills out that information about what's actually happening. That's what the committee experts are really going to appreciate. General principles. So SMART recommendations, I've mentioned them before. When you're thinking about what recommendations to make at this stage, remember your audience. It's treaty body experts. They have time to be a little bit more thoughtful and a little bit more nuanced in their recommendations. And the recommendations are issued in writing. So you can mention specific articles that need to be reformed or specific provisions in, the criminal procedure code or things like that. You can be more specific about what your ask is, what you want them to recommend. And another really important thing is to connect issues to solutions. So as you're doing your desk research, as you're investigating these various issues that you raise in the report, make sure that for every issue raised, there's a recommendation or a question, if you're doing a report at the list of issues stage, that helps address the problem that you raise. So don't leave a disconnect. Don't have a recommendation that's untethered to anything in the report or a question that's not connected to anything in the body of the report, but also make sure that there's a solution for every problem that you raise. SMART recommendations, I'm guessing you're familiar with this acronym. We want to make sure that the recommendations we are proposing are specific, measurable, achievable, relevant, and time-bound. We don't typically need to give a time frame for the recommendations because there's a sort of implicit assumption that the recommendations will be implemented by the next review, by the beginning of the next review cycle. But do try to make sure that the recommendations you're proposing are sufficiently concrete and meet those standards. Sometimes the treaty bodies will water them down a little bit, but we try to propose things that are rigorous in an effort to try to encourage the treaty bodies to request or to make strong recommendations to the countries they are reviewing. Just a few notes about working with partner organizations. Some of the pro bono teams are going to be working with partner organizations. I'll put you in touch with those partner organizations. It's really good early on to have a conversation with them to figure out what their priorities are for this particular review. Like, what recommendations do they want the experts to see? You can give them the recommendations that came out last time around so that they can kind of understand what they're looking for, what are some examples to shoot for, so that they understand a little bit about the context. A lot of our partner organizations don't have a lot of experience doing advocacy with these treaty bodies, so you can sort of help them manage their expectations as well. And then really what our partner organizations can do in terms of not only setting those priorities, like this is a really important issue, this is a big problem, and that can help you focus your attention in the report, is ideally our partner organizations are going to be able to feed you information. It might be published information, it might just be that you interview them, you get on, a Teams call or a Zoom call and just talk to them and say, okay, tell me all you can about this. And you're just taking down notes and you're incorporating that information that you get from them orally into the report. And be sure, if you're doing that, you talk to them about how you're going to cite that. Because you can certainly cite them by organizational name, interview, and the date of the interview, if they're okay with that. Some of our partner organizations don't want to be named so explicitly. And so you can just say interview with a civil society organization based in the country, or you can even skip the based in, and then the date of the interview. And then just make sure you hand off your interview notes to me so that we can keep that on file at the Advocates for Human Rights, and you don't have to worry about being the custodian of those documents. But our partners are generally really lovely, but also just keep in mind they're super busy as well. And so it might be hard to connect with them, be persistent, and try to be creative about different ways to reach out to them. Some might just prefer a WhatsApp call or something on Signal versus a traditional Zoom or Teams call that you might be used to setting up. So try to be as flexible as you can if you're working with a partner organization. And I've tried to build in time for you to get me a draft so that I can review that draft and I can then send it to the partner organization. So if you want to give the partner organization an outline, if they want that, go ahead and do that. But just keep in mind, I'll do another revision before the draft goes to the partner organizations. I've built in that time so that we can do that. So that's a little bit about partner organizations. And now we have come to our end. I put at the top the deadlines for the Iran report and the Maldives CERD report. Our deadline is June 20th for Laos, July 25th. August 1st deadline for Malaysia, the Maldives CRC report, the Uganda CRC report, August 15th for Brunei, Jerusalem, India, Iraq, and Vietnam, and August 25th for Nigeria, Somalia, Uganda. It's going to be a busy summer for me and for all of you. We are just so thankful at the Advocates for Human Rights for the pro bono support we get from all of you and your firms to help us do this reporting. There's no way that I, on my own, could do all of these reports. Given the limited time and scope, you're really helping us amplify our advocacy and amplify the voices of our partner organizations and really help the people who are under sentence of death in these countries around the world make sure that they're heard and make sure that the experts at the UN are able to leverage their influence to press these governments to reduce their use of the death penalty and ultimately to work toward abolition of the death penalty. So it's really meaningful that you are helping us do this work, and we are really appreciative of all of your support. I hope it's a great learning experience for you, and I really look forward to chatting with the individual teams to see if you have any questions for me or if you want more guidance about particular things. Feel free to reach out. You have my email and my cell phone up on the screen, and there's a link to a chapter if you prefer getting information in more written format. You can take a look at that as well. Teresa will, if she hasn't already she will send you, the templates and the checklist and some examples of reports we've done recently. So hopefully that will give you enough guidance, and happy to do a check-in later on in the process as well. But thank you all so much for your attention and for helping us do our death penalty advocacy, working to abolish the death penalty worldwide.